Mr. Bampton.
Lord, before I proceed, there's one point that Lord Hughes put to me this morning, which I didn't deal with very well. My Lord asked a question about the case of Turnsbag. There's a paragraph, which one is it? Can you tell me? It doesn't matter. There's a paragraph which ends up suggesting that the reason why the penalties were lifted, decided in favour of the newspaper, was that the newspaper won, which is logical enough. Not because the penalty in itself was disproportionate.
Yeah.
There are cases, however, in which the mere size of the penalty has been enough to get it declared incompatible. And the main one on that is Tolstoy.
Thank you.
Which
yes,
is in volume 1, I think, I don't know what. Volume, which?
Volume 12.
Volume 12 at 5050.
Thank you very much indeed.
I remember that one with some pain because I was in a case in this country, so largely responsible for a war of £1.5 million in damages, but there you go. Lords, can I proceed straight away? I don't need to remind your Lordships of anything in Campbell. I think I've already said that it's inescapable, that it's irreconcilable, whatever some of my learned friends may say, it's irreconcilable with the decision of the European Court in the MGN case, the successor case. Campbell, the House of Lords in Campbell held that the scheme was a proper scheme, served the legitimate aim of providing access to justice. The European Court decided, despite that, they recognised it had a legitimate aim, but they nonetheless threw the whole thing out lock, stock and barrel because it was a violation of Article 10. It's a stark choice, as I think I said this morning. Can I go briefly to the European case, which is at volume 12, tab 3, page 4806.
Yep.
And can I go straight away? I did refer to some of it already this morning. This is what I'm going to, it's paragraph 168 on 4854.
Thank you.
I noticed straight away that this is part of the submission of the applicant, but it's a submission to which I adopt, so may I read it? It reflects something, perhaps, that was said in the Lawrence case, to which I shall come in a moment. Sixthly, publication cases were sufficiently distinguishable from other civil litigation for the CFA traffic scheme to exclude such cases. To say traffic notice, for the CFA scheme to exclude such cases. The applicant reiterated the reasons outlined by Lord Hoffman at paragraph 67, that's in Campbell, that's paragraph 19 of his judgment, the speech, sorry, as to why the CFA success fee system had a heavier impact on publication cases compared to other cases such as that. That is my submission. 2, it is the reason why Article 10 cases are different from others. Next reference, and again these references are very short, is on page 4858 at paragraph 192. This bears upon a separate question in this case, which is in a sense a question of remedy. What's to be done if we're right? At E, just above, the figure 1, was there an interference?
Which paragraph is this?
I'm sorry, my lord, 192.
192, thank you.
48581,
Yes.
bottom of the page. The applicant's complaint, as noted in 157 above, concerns the impact on it of a costs award, which under domestic law included success fees calculated almost twice most of the base costs of 2 appeals to the House of Lords. The court considers, and it was not seriously disputed by the government, that the requirement to pay these success fees as an unsuccessful defendant in breach of confidence proceedings constituted an interference with the applicant's right to freedom of expression guaranteed by Article 10 of the Convention. One asks whether, if the government had been as it were, notified of this case, it would have maintained that position, this being a defamation case as opposed to a breach of confidence or privacy case. 193, the fact is emphasised by the government that the underlying legal regime was permissive in that it permitted a CFA, including success fees, to be concluded rather than requiring it, does not change the fact that the applicant was required, pursuant to a court order for costs, to pay costs including the impugned success fees to the claimant. That's, as I said this morning, the apparatus born of the legislation which is permissive is compulsory in all cases, which suggests that the remedy, if there is one, has to concern the apparatus and not the legislation.
By the apparatus, you mean the
rule of court, which says...
rule of court and the way in which the discretion was exercised in the particular case.
No, that's the first part of my case.
Yeah, I understand that, but you're also complaining that it was the duty of the judge,
yes,
when awarding costs, not to include the additional items.
Yes, I'm not sure that there's anything the judge could have done about that. What the judge should not have done was to have awarded all the costs against me. That's my part one.
That's your part one point. I'm simply asking you, what should the judge have done?
The judge was bound by Campbellman, or there's nothing the judge could have done. Right. What she would do now, knowing, if I'm right, that such an order is unlawful under Section 6.1 of the Human Rights Act, is not make the order.
So
qualified in such a way.
Not make what? Not make?
Not make an order for costs which involves payment of the additional liability.
Leave out the additional liabilities.
Right. So that is in fact what the judge ought to have done, whether or not she realised it. Is that right?
Well, she could have done, perhaps, if she'd not been bound by the decision of the House of Lords in Campbell.
Yes, I see.
She could only do it by striking out,
yes,
she? Some subordinate legislation.
Yes, and that is exactly...
She had no discretion to do it.
No, it's not a matter of discretion at all. If that order is unlawful under Section 6.1, she cannot make the order.
Yes, but in order to make the order, she has to strike out some paragraphs in the CPR definition, little a, that you referred to.
This is on remedy. This is the main problem. That's a very difficult thing for a court to rewrite an order in that way. I think that goes beyond reading down. That is to say, I'm going to rewrite this. I'm not having that. I'm going to put in some provisions, some qualifications, exceptions. And that's very difficult to do. Ultimately, it may be the only remedy, and I'll show you, Lordships, in a moment, what happened to a case from Northern Ireland in the House of Lords, is to say this is unlawful. No court can make this order in future.
Is that the necessary consequence? I mean, there is a problem, isn't there, in a case where even on the footing that it has been found that the order was non-compliant, litigants have nonetheless acted on it,
yeah,
and retrospectively depriving them of the costs regime on the basis of which the litigation was undertaken, itself raises really quite significant problems.
It is a real problem.
Not only in relation to legitimate expectation, but arguably in relation to their Article 6 rights.
Absolutely. I don't deny.
So how do we solve that?
The court has got to make a choice. I don't think your lordship was in the case, but there's a case called, which is in the, I'll come to it if I have to, which is in the bundles, called In Re Spectrum. And it was a case in which the question of what was called prospective overruling was considered at length by the House of Lords. I think it was the House of Lords.
Yes, it's not prospective overruling that I'm on about. There may be some circumstances in which the right course, the only course consistent with justice, is to apply the non-compliant rule and simply leave your clients to go to Strasbourg and ask for financial remedy from them.
Of course. I recognise that choice. I have to argue, as I do, that in circumstances of a case like this, this is a battle between access to justice and private rights under Article 8 and the greater public right, if you like, of freedom of expression. Yes. And my argument is that in this case, that is why this court said in the majority judgment, which I think your lordship was party, that publication cases are of a wholly different character to the ordinary case, because the power of the Article 10 right is so great in a democracy. That has to be my argument. It's the argument that was advanced in MGN, and it succeeded.
And the reason you cite Spectrum Plus is because you say that one option is for us to say, beware claimants, this is now the law.
Yeah, that's right.
But we don't apply it to cases that have gone on in the past.
Well, I believe, I'm not a judge and I'm not the Supreme Court, far from it, but I believe that is a real difficulty.
I understand.
To invite the court to say that all cases that are in the pipeline are invalid and have to be uprooted, as it were, is very, very difficult. I see the problem. So what was suggested by Lord Nichols, the court went on many pages and never reached a solution.
Exactly.
What you can do is to say, we will set aside the rule, as it were, we will not disapply the penalty in this particular case, and for the future, so that people know where they are.
That was a question of the common law, and it could be argued that if it's more difficult for the common law, maybe you'd say maybe it could be argued to be easier in the context of human rights.
Yes.
Law. But anyway, I see the point. Yeah.
I don't pretend to have a solution. I will show your lordship in due course how it was solved by the House of Lords in the Northern Irish case.
But I mean, it's a bit too late for taking a Spectrum Plus line, isn't it? Because the costs regime that you're complaining about has been rescinded by subsequent legislation. And it's anybody who has already embarked on the litigation on the basis of the old regime in those cases where it continues to apply because of the time the action was begun, is already stuck.
Yes,
so
it may be
effectively, the Spectrum Plus solution is no solution in this case.
It hasn't been rescinded for press cases, privacy cases.
It never has been. It's still a present threat in publication cases.
Yes, that is true.
Well, that's quite a big field of important public interest.
It always seems to me an extraordinary situation, which is no doubt why we've never actually applied the Spectrum Plus idea. You select the present case, because it's been bold enough to be brought. Other cases in the pipeline you leave in Stuck.
That's right.
But future cases, well, you cater for them. I mean, it's very odd.
It is, and it's
well, we don't need to consider this line, do we, for present purposes, or do we?
What?
Do we need to consider it because we're not now in the common law territory? We're in more in human rights territory.
No, I agree.
Maybe a jurisdictional issue that goes equally to both. I don't know, but
it's an option. It's an option which is weakly suggested right at the end of our argument as a way out of a difficulty. I don't believe, in the end, if I'm honest, that it's going to work. I believe what has to happen is that a way is found of disapplying the CFA system to meet the needs of this particular case, and I think it can be done.
On the basis of the overwhelming importance of Article 10, the alternative which Lord Sumption was putting to you is the frozen rabbit alternative. You sit in the middle of two unacceptables, namely breach of the freedom of expression, but also breach of legitimate expectation.
Yeah.
And you simply say we can't do anything, and someone can sue the UK in Strasbourg.
well, it almost becomes a question of who's going to be the claimant in Strasbourg, doesn't it?
Thanks very much, is what I say to that. I don't want to be in Strasbourg. I prefer to stay here. Of course, it's cheaper. Meaning the Times newspaper. But there is a way, I believe, whether it's acceptable or whether it's attractive to this court, appealing as another matter. Can I come to that later on?
Yeah, well, fairness, you have to warn you, you've got
I've got
34 minutes, yeah.
I haven't got a lot more to do either, but if I'm going to answer questions for the next 34 minutes, I'll have run out of time. Can I, just in relation to, where was I, Campbell, I don't need, I think, to say anything more about it. Except that Lord Hoffman recognised the difficulties which the regime creates, but thought he couldn't overcome them because the scheme was compliant and legitimate. Can I just, before I leave the authorities and come to the end and the remedy case, can I just... What?
You didn't finish MGN.
I didn't finish MGN, oh golly. Yes, well, there you are. That's what happens if you get pushed off the road. Where was I going next?
Frozen rabbit has been pushed off the road.
192 to 3 I did do.
Yep. 198 you were going to go
198 I was going to look at.
So we go to 198, do we?
No, I think not. It's
Conclusion, 212.
yes. I wanted 201. This is the conclusion in one sense, but there's a further conclusion. That's on page 4860 of MGN.
Yeah, careful scrutiny.
This is old hat, I don't mind saying, but for my purposes it's a good old hat, so I will read it if I may. 201. However, the court has found the most careful scrutiny on the part of the court is called for when measures taken by a national authority are capable of discouraging the participation of the press in debates over matters of legitimate public concern. It is, moreover, not necessary to consider, this is important, in any particular case, whether a damages award has a chilling effect on the press as a matter of fact, so that, for example, unpredictably large damages awards and defamations, and I would say costs, defamation cases, are considered capable of having such an effect. We've been there before. The chilling effect is very important. Then the conclusion itself is at 218 and 219. That's page 4864. On the one hand, the claimant was wealthy and not in the category of persons considered excluded from access to justice for financial reasons. That does not apply to Mr. Flood, I accept. Her representatives accepted in the domestic proceedings they did not do much CFA work, which limited their potential to act, so on and so forth. The applicant's case was not without merit, in that the Court of Appeal and a minority of the House of Lords considered that the impugned articles did not violate Mrs. Campbell's right to life. I do distinguish ourselves, from that. We come here having, by an accident of judgment or misjudgment of ourselves, having lost some part of the case, we come here as the principal victors in the proceedings. On the other hand, while accepting that the proceedings were lengthy and somewhat complex, the total cost billed by the claimant as regard the two appeals to the House of Lords amounted to 850,000, of which 365,000 represented success fees. It's a bit more here, but then times have moved on. That was 6 years ago. It's true that the applicant in the end reached a settlement and so on and so forth. However, given the finding of the House of Lords and of the judicial taxing officers in the second appeal, as well as in the similar above-cited case of Designers Guild, success fees were clearly recoverable against the applicant and further at the rates of 95% and 100% in the first appeal and 95% for the solicitor's costs in the second appeal. Those are the percentages with which we are faced in this case. Accordingly, even if it is not possible to quantify with certainty the precise amounts paid by the applicant which can be attributed to success fees, it is evident that the negotiated cost settlements reflected the obligation on the applicant to discharge substantial success fees. Finding such circumstances, the court considers the requirement that the applicant pay success fees to the claimant was disproportionate, having regard to the legitimate aims sought to be achieved and exceeded which it was accepted they were, and exceeded even the broad margin of appreciation accorded to the government in such matters. That conclusion, if it's to be followed, means that this scheme must be disapplied at least so far as the victims of it, in this case my clients, are concerned. It is inescapable that the scheme has created, by imposing without choice and without qualification 100% or 95% uplifts on losing defendants, has created a situation which is in conflict with Article 10, and in the view of the European Court in MGN Limited, that overwhelms or outweighs the private right of the claimant. As I said earlier, it's a stark choice. May I propose what the reason, in very short terms, what the reason was why the reasons were why the European Court reached that conclusion. It goes back to what I said at the outset about the importance of a free press conveying important information to the public. The European Court of Human Rights condemned the whole scheme because of the threat that it presented to the proper exercise, indeed the survival, of the kind of journalism that ensures that the public gets the kind of information it needs to have. This is a top-down case, if you like. We are at the top end of that consideration, a public interest consideration. Chop our heads off and the heads of people like us, and the public will not get the information it needs to have. There will be public officials, there will be powerful businessmen, there will be football managers, there will be all sorts of people and organisations that can get away with, not literally, but in the colloquial or the metaphorical sense, that can get away with murder, and it will never be known about, because the press are terrified of being sued because of the cost. Bad enough as it is, the amount of cost that is involved in litigation generated in this field of the law in our country, but 100% on top of that, we would say that this case was, par excellence, I say, an example of that kind of journalism. It is therefore necessary, because the order is in violation of Article 10, it is necessary to disapply it with the result that orders made under it are unlawful. Now, before I come to the last of my authorities, it is perhaps, this is, I'm afraid this is close to Newcastle, but it is necessary, if I may, to invite your lordships to have a quick look at Lawrence and Fen Tigers. Not very much, fortunately. Much of it is not concerned with a case of this kind. That was an Article 6 versus Article 6 case, if I can put it like that, as far as I can tell. At its reference in the bundles is Bundle 8, Volume 8, Tab 6, page 2810. And here, my Lord the President, Lord Neuberger, does what, a much greater, and if I may say so, more compelling way, he does what Lord Hoffman did at paragraph 19, no, it wasn't 19, it was later, in what he did in Campbell against newspapers. The two different meanings of proportionality. And it's a problem which means that, or the way it's analysed here, which we respectfully adopt, means trying to fiddle with practice direction and so on and so forth does no good at all, because it won't get you into the realm of balancing convention rights, proportionality. There is paragraph 29 on page 2821. The concept of proportionality lies at the heart of this case. It is important not to confuse two different meanings of proportionality, which are in play here. Lord Hoffman made the same point in paragraph 23 of his speech in Campbell. That's the paragraph I wanted. The first meaning of proportionality is that with which we're familiar in the context of the Convention. A valuable recent statement of what proportionality in this sense entails is to be found in Bank Mellet against HM Treasury number 2, 2014, appeal cases 700. Lord Reid, Justice of the Supreme Court, said this, and there are a number of... perhaps I read the whole thing. And
Would you rather we read it? If you,
well, I would
if you want to read it, that's fine.
No, my voice is very tired and no doubt very boring. It happens. Can I ask your lordships to remind yourselves of the first bit down to the end of paragraph 30, and I'd like to return to reading at 31.
Yes, as you say, this is quite familiar. Lord Sumption said much of the same thing in that case.
Yes.
And 31 is the standard approach
Yes.
which this court applies to the exercise of a proportionality evaluation in almost every human rights case.
Absolutely, but it's a clear modern statement of the nature of proportionality in a case like this.
Indeed, sir.
There are two parts of 31, the citation from what Lord Reid said, that are important. The first is number 3. It is necessary to determine whether a less intrusive measure could have been used without unacceptably compromising the achievement of the objective. The objective being to allow people who can't afford it access to justice and in order to assert their convention rights. The answer to that is yes. But that is not something for barristers not even the court, to attempt. That is a matter for government. All I will say, it is impossible to suppose there is not a more conceivably less intrusive scheme than the one we're crushed by at the moment. Plainly, there could be a less intrusive scheme. There could be a scheme which made proper provision for convention rights. There isn't. I can't make the court do it, and the court can't make the government do it. But it should be done. It is there if it's needed. And it hasn't been. They've had every opportunity.
Well, you have in your favour they found the government's statement in recorded in MGN against the United Kingdom at
Well, there's no
214 that the government didn't believe that the present maximum success fee in defamation proceedings is justifiable in the public interest. So
didn't. No, I know.
So you have that in your favour.
Done anything about it.
Yes.
But what I'm saying is, my lord, is this: there's nothing I can do about it, and I don't know there's anything your lordship's court can do about that. It's a matter for government. All I can say is it is there, it is possible, and which is what I think is Lord Reed is saying. And that's one of the factors perhaps one takes into account in estimating where the balance lies in a proportional exercise. If the remedy is there, no matter what it might be, but plainly it is, then that's something which goes down on the side of the applicant. This is disproportionate. It needn't be. Therefore, you can decide the case in my favour. And 4, which is also in the same pan of the scales, whether balancing the severity of the measure's effects on the rights of the persons to whom it applies against the importance of the objective, to the extent that the measure will contribute to its achievement, the former outweighs the latter. Put those two things together, and what one can say is, in this case, as Strasbourg thought, interests of what you might call freedom of expression, serious journalism, outweigh those of the private individual. What is more, that could have been provided for in specie for publication cases or certain kinds of publication cases, and it hasn't been, but it still could be. Those are both considerations on my side, on our side of the argument, we would say. Now, my Lord, Fenn Tigers, sorry, Lawrence, just a long time since I got through an argument without even mentioning a head note, but I'm not going to do that this time. The first meaning of proportionality is, this is in 30 on page 2821. The first meaning of proportionality is that with which we are familiar in the context of the convention, and then then there's a citation from Lord Reed in Bank Mellot. What? What? I've done that, sorry, I got interrupted and I've gone. Done it. Yeah, quite right. Don't need any more from there. 52, I think, is the next one, and quite possibly the last, actually. Yes, 2827. Well, this is obviously of some critical importance in this case, because this was a convention case too, Lawrence was. The rights in competition with each other were, however, different. In that case, as I think I said earlier, it was Article 6 against Article 6. Not unimportant rights, I don't say that. In this case, it's Article 6 and Article 8 against Article 10. And I read this paragraph with that consideration in mind. Over the context in which the court made these criticisms, whatever they were, was its concern about the effect of the scheme in defamation and privacy cases. That was a reference, I think, probably to the two cases I cited earlier. The right of freedom of expression is always given particular weight by the European Court of Human Rights. As the court said at paragraph 201, the most careful scrutiny is called for when measures are capable of discouraging the participation of the press in debates over matters of legitimate public interest. It concluded that a fair balance had not been struck between the Article 10 rights of the defendant publishers and the Article 6 rights, and one should add in there, and 8 rights, of appellants who allege defamation or breach of privacy. But in our judgment, the balancing of the Article 6 rights of appellants against those of respondents is against those, that is the same rights, 6 rights of respondents, is an exercise of a wholly different character. Now, that was my Lord Neuberger with Lord Dyson, who was then the Master of the Rolls. He had with him, in saying that, Wait a minute. My Lord Sumption and Lord Carnwath, who isn't here. So that's at least four. My Lord Mance was, I think, I don't like the word, but I think it's the right word. It was more nuanced in what he said. And one can find that. I'm not going to read it out. At 101 to 103. It's to the same effect, but it isn't quite so categorical. Your Lordship would like to look at it. I'll read it if you'd like me to. Can I read 103? It's only right that I should do so, I think. Lord Mann said this is page 2839. While freedom of expression is a particularly powerful interest under the Convention, the interest of any respondent in being able to defend himself or itself in litigation at a reasonable and proportionate cost is, in my opinion, also of some weight. I would certainly assent to that. I don't deny it. And it certainly engages, as I understand Lord Newburgh and Lord Dyson to accept, a balancing exercise. Indeed it does, when set against the countervailing interest that the appellant should have the access to justice which the system was designed to give. Well, I heartily concur. My answer, if an answer is needed, my comment would be, the question is, in a publication case, in a case where the public interest is at stake, not at stake, but is involved, engaged, and in this case, certainly, the question is whether Mr. Flood's Article 6 and Article 8 rights are outweighed by Times newspaper's Article 10 rights. According to the European Court of Human Rights in Strasbourg, they are. It's unequivocal. And the reason is all that jurisprudence I read out earlier has a peculiarly high value, freedom of speech, and that is why the European Court decided the case in the way that it did. Not simply that Article 10 rights always outweigh Article 6 and Article 8 rights, that would be a nonsense, but because the pressure of the scheme on the Article 10 rights was disproportionate to the benefit conferred on the applicant who needed access to justice to assert his Article 8 rights. It was the vice of the scheme that it penalized the exercise of the right of freedom of expression in a very, very severe way. Many of these cases use the expression severity of the measure. That was what Lord Reed said in the Bank Millet case. Lord, finally, can I come to a possible solution to this difficult problem? That is the case of In Re G, or Re G, perhaps I don't know. I would, yes, I don't think I need to know that. In Re G, which is in volume 7, tab 6, 2472. As one can see, and I've gone back on myself, so this, I will refer to the head note on page 2472, so what the case is actually about. The facts. I have got time, just. The applicants, a man and a woman who had been living together since before the birth of the woman's 10-year-old child, but were not married, wished to apply jointly to adopt the, sorry, I should say this case was decided in 2008, to adopt a child in order for the man, who was not the child's biological father, to be formally recognised as the father, while maintaining the woman's status as the legal mother. However, Article 14 of the Adoption Northern Ireland Order of 1987 provided an adoption order could only be made on the application of more than one person if the applicants were a married couple. The applicants applied to the High Court in Northern Ireland for declaration that Article 14 of the order was incompatible with their rights under Articles 8 and 14 of the Convention, as given effect by the Human Rights Act, and that they were eligible to be considered as adoptive parents under the 1987 order, regardless of the fact that they were unmarried. The judge refused the application. The Court of Appeal held that being unmarried was not a status, and so that Article 14 was not engaged, and so he upheld the judge's decision. The holdings, I don't think matter at this stage. What matters, the House held that that was not a proper situation, that unmarried status should not be a bar to adoption, and that the order, or whatever it was, Article 14 of the adoption order was a breach of their convention rights. The question was what to do about that. At page 2478, one finds the speech of Lord Hoffman beginning, and I think go straight to paragraph 3. He says this: on the other hand, section 6.1 of the 1998 Act, that's the Human Rights Act, provides that it is unlawful for a public authority to act in a way which is incompatible with a convention right. And the Family Division of the High Court is, for this purpose, a public authority. So is the Queen's Bench Division in London. If the 1987 order were primary legislation, section 6.2 would require the court nevertheless to give effect to it. But the order is not primary legislation, laws any more than CPR 43.2.1a is, as defined in section 21.1 of the 1998 Act, and is therefore overridden by convention rights. Now that is quite a bold statement. The other judges, in different ways, all agreed with it, except I think Lord Walker, who was a dissenting. Lord Hoffman concluded his study of the problem in paragraph 38 on page 2488. The House should say, in my opinion, this is just above letter B, last sentence of the paragraph. The House should say in my opinion, should say only that it is unlawful for the Family Division to reject the applicants as prospective adoptive parents on the ground only that they are not married to each other. In the event, one can see what it was, and Lord Mance was in this case too, one can see what it was the court concluded should be the order that they made. And that's right at the end on page 2523. The appeal was allowed, and it was declared that it is unlawful for the Family Division of the High Court of Justice in Northern Ireland to reject the applicants as prospective adoptive parents on the ground only that they are not married. And that is a piece of subordinate legislation declared unlawful because of a breach of convention rights by the House of Lords, predecessor of this court. I see no reason why, if your lordships thought, that's the primary question, of course, that this scheme was incompatible with Article 10 of the Convention and that there had been a violation of, or there would be a violation of our Article 10 rights by the imposition of the additional liabilities, whether in relation to the part of the case which we lost, or more particularly, perhaps, more undesirably, perhaps, or I don't know quite what the word is, in relation, if we should lose the first limb of our appeal, in relation to the cost of the part of the case that we won, that should be what this court should say.
Was there any argument in this case about the possibility that the court might apply the offending legislation, notwithstanding that it was incompatible?
No.
I don't see how it could have arisen on these facts. So they didn't have the dilemma that we have.
I didn't say that it had. A similar thing occurred in a case called Marx against Belgium, way back in 1970-something. It's in the file.
What happened in this one, Mr. Anderson? This was an appeal, or was it? It may not have been. Sorry.
No.
Was it an appeal from the refusal of the adoption order?
Yes.
Or was it some other form of process?
Sorry? Was it what?
Was it an
No, it seems to have been an application for adoption which was refused.
Originally, clearly, yes. What I was asking was what came to this court. Was it an appeal against the refusal of the adoption order? Because the one thing the court doesn't seem to have done is to have made the adoption order.
No.
Threshold of what?
What it's done is to make a declaration of legality.
The question was whether they'd qualified to cross the threshold of adoption. Did they have the status?
Yeah. Oh, I see, because that hadn't been investigated at all.
Exactly.
Yeah.
Their suitability had not yet been assessed.
Exactly so.
They
The
claimed a
court did
declaration.
say, the court did say at the end of Lord Mance's judgment, did say there's not, this decision says nothing at all about their suitability. They could still be refused on the grounds
Right.
they're unsuitable as people.
Yeah, okay.
But their status was not a ground for refusal.
Yeah,
And that's what was declared on. They're saying any
yes.
court in Northern Ireland, family court, that did not open the threshold for consideration of the individual case, simply on the ground of status, would be making an unlawful decision.
Well, we sometimes are asked to make declarations
Yes.
of legality where a coercive order, for one reason or other, can't be sought. There it couldn't be sought because, as you say, the suitability of the applicants hadn't been gone into.
That's right.
But what happens in the present case, if we were to make a declaration that the inclusion of the additional liabilities is unlawful, where does that leave you?
Well, I hope it leaves my clients in the position of not having to pay them. The problem is the one that Lord Sumption mentioned earlier. What does one do about all the other cases? And this is something that, this is a powerful consideration that led to the decision not on an Article 10 case, but in the Article 6 case in Fentigers. What the reasonable expectation point?
Well, I'm not sure about that. I think in Fentigers the reasonable expectation was the case itself. It wasn't other cases. It was
Well, that's true, but one
claimants had a reasonable expectation to be able to get there.
That's true. That's the problem with which the House of Lords grappled in the Spectrum case without solving it.
Well, that would also be true, of course, of every other case which is in the pipeline,
Yes, of
where
course.
somebody has already committed himself to a success fee and an ATE insurance.
Can I put it bluntly? The effect of MGN versus the United Kingdom is yes, but too bad.
I see.
Must be, if it's to be followed. And I would suggest that it should be followed for these questions of what is in the public interest to be read by the public are of not supreme importance and not always of predominant importance. But they are so important that they really cannot be allowed to be overwritten or eroded by a scheme which is in itself so flawed.
But you make that point, as I understand it, on the basis of the supreme importance of the interests protected by Article 10, rather than as a matter of jurisdiction.
Matter of jurisdiction?
Well, you don't deny, as I understand it, that we have the power simply to apply the existing law because of the legitimate expectation point. You say that we shouldn't exercise that power because of the supreme importance of the values reflected in Article 10.
That certainly, but also because of the imperfections in this scheme, which needn't be there, which have had an effect on Article 10 rights, which needn't be there. And I can put it, the scheme devised in pursuance of the legislation could have been quite different. It could have had carve-outs, it could have had qualifications, it could have had provisions. It had none of those. It is a blunt instrument which is apt to crush the human right in freedom of speech flat because of its effect on the publisher.
But you're also making, as I understand it, a further point that such expectations as litigants had, at least after 2011, weren't legitimate because of NGN against
Well, that's also, but I can't make
that doesn't help you in your case.
No, it doesn't at all, because Mr. Price's client did have those legitimate expectations. Of course I accept that. But sometimes the good has to go out with the bad. Mm-hmm. And this is the awful thing about these cases. I am certainly sympathetic to the idea there will be some good, sensible people with good, sensible claims who will be caught by a decision like the one I'm proposing. I can't do anything about that because I say the consideration that this sort of journalism should not be penalised by a scheme as badly drafted and as indiscriminate in its effect is paramount. And that's how, it's the only way I can see of getting home.
Can I just pursue your answer to Lord Sumption, because I think you aren't accepting, really, that the court would have jurisdiction. If the court concludes on the balancing exercise that you're right, the Article 10 interests outweigh everything else. Mr. Price's client may be tough for them, but too bad. In legal theory, perhaps they should have realised what the Article 10 interests weighed, how they weighed. If you're right about that, then the court would be acting illegally to enforce the scheme, wouldn't it?
No, because the court is
Contrary to the Human Rights Act.
no court is making a choice between two human rights.
Well, I know, but if one outweighs the other,
Yes.
then the legal course is clear, and there is only one legal course. And the point I'm putting to you is that it becomes then, once you form that judgment, that Article 10 outweighs any other interest, it would be contrary to the law to do anything except give effect to the Article 10 rights. And the Human Rights Act bids you to do what is required under the Human Rights Convention, and you have to do that.
But you are also required under the Human Rights Act to balance competing rights.
Of course.
Necessarily.
We can't say to someone, look, all right, you had a good shout. You had a 35% chance. I'm going to award, I'm going to discount all these costs, but I'm going to give compensation to Mr. Price's client, so that we don't have power to do that.
No, well, in Strasbourg, I mean,
It's only Strasbourg which can look at the thing in the round and say the UK has got into a situation where there are two competing rights and two people have been potentially wronged. If one of them prevails, the other must be compensated.
Not necessarily. I mean, if it's a case of the individual, a question of the individual case, I think I can argue with some persuasive force that Mr. Flood, if he's the individual concerned, ought at some stage, long before the trial of the Reynolds defence, ought to realise he ought not have brought the action.
Yes, I see.
And
But if you're right, Mr. Hampton, doesn't this follow? It's just a question of remedy. But if you're right, then the application of the civil procedure rules section, which adds in the additional liabilities, is in relation to publication cases unlawful.
Yes.
It's as simple as that.
that is right.
It's not primary legislation. There's no difficulty in us saying so, if you're right.
That's right. And if I'm right, then the court, as your lordship has just said, and my learned junior's note also says, the court cannot then uphold the scheme because it would be unlawful under Section 6.1.
In relation to publication cases.
In relation to publication cases. I wish I could say in relation to publication cases of this kind.
Quite.
I wish the government had allowed me to say it, but it didn't. So that's it. I think I'm more or less on time.
You are. Thank you very much indeed.
Unless there's anything else.
Thank you very much, Mr. Rampton. Ms. Wilson?
No further submissions.
Thank you very much. Mr. Miller?
I appear with Mr. Silverstone for the appellant in this appeal. My learned friend, Mr. William McCormick, QC, appears with James Laughlin for the respondent. In this appeal, Associated Newspapers Limited contends that a costs order requiring it to pay the respondent's additional liabilities in the total sum of £835,000 would be incompatible with Article 10 of the Convention. Like the appeal in Flood, this is a newspaper defamation case. It was commenced and the CFAs and ATE insurance contracted into in 2009. It therefore falls under the original 1999 Access to Justice regime for recovery of additional liabilities. That applied across the board before the 1st of April 2013. Although, as the court will be aware, this regime still applies in all publication cases in any event. This is the consequence of the LASPO Commencement Number 5 and Saving Provision Order 2013, which is at Bundle 4, Tab 14, page 1135. The award of damages was £65,000. The respondent's base costs have been agreed and paid in the sum of £633,000. The additional liabilities, which, as I have said, total £835,000, comprised success fees of £587,000 and ATE of £248,000. As with the other two appeals before the court, the challenge is based on the judgment of the European Court of Human Rights in MGN versus UK in January 2011, and the Article 10 principles underlying that decision. We contend that the operation of the 1999 Act regime for recovery of additional liabilities interferes with the Article 10 rights of publishers in a way which cannot be justified under Article 10.2. The proposed order for additional liabilities in the sum of £835,000 in this case demonstrates that to be the case. It would therefore be an unlawful order, as incompatible with ANL's convention right within the meaning of Section 6.1 of the Human Rights Act. Since the order to pay would not be mandated by the 1999 Act itself, the relevant statutory provisions simply allowing the recovery of additional liabilities, and since none of the provisions made under the primary legislation that would contribute to this outcome violating the Article 10 right have to be read and given effect to by the court in a way that produces such an outcome, Section 6.2 of the Human Rights Act does not disapply Section 6.1 and save the order in costs from a finding of unlawfulness under Section 6.1. This makes Section 6.1 mandatory, and there is no jurisdiction in any court to act unlawfully, which is the consequence under Section 6.1. It's common ground that the 1999 Act regime which applies in this case is the same as that which was before, which the European Court of Human Rights was considering in MGN versus UK. This was the basis on which the issues were argued before Mr. Justice Mitting, from whom this appeal comes as a leapfrog appeal following a hearing on the same issue last year. And I'll simply give you the reference for that. It's paragraph 7 in Mr. Justice Mitting's judgment, volume 2, tab 7, page 703. There are essentially three elements of the 1999 Act's regime in issue. These are, first, the recoverability of CFA success fees charged as a percentage of base costs. These can be between 50% and 100% of the base costs. The central problem with this part of the regime is that the stronger the publisher's free speech defences to the claim, the higher the percentage success fee the claimant's lawyer will charge. This has the result that in an evenly balanced case, 100% uplift or something close to it is standard after the early stages of the litigation.
Basically, the more reasonable your defence, the more greater your exposure.
Yes. This aspect of the regime increases the pressure on publishers facing a CFA claimant to settle claims where there are stronger rather than weaker free speech defences. For the same reason, it's capable of inhibiting the publication of such journalistic material in the first place. For example, an article which defames the claimant or contains the claimant's private information, but in respect of which there is a 50% chance of a successful defence of truth, honest comment, or public interest speech, is less likely to be written. We say that, given its adverse consequences for freedom of expression, this part of the scheme cannot conceivably be justified under Article 10.2 in publishing cases. This is an area of litigation where the number of claims is small and in which the majority of claims succeed, if you're including in the concept of success settlement, because the majority settle. This being so, it's not justified by a need to ensure that lawyers will take on such claims. Recoverability of high percentage uplifts are simply a penalty on the losing publisher and a guarantee of windfall profits for the claimant's lawyers.
Isn't that circular? Because you say that newspapers are being forced into settlement. If they weren't forced into settlement, perhaps there wouldn't be any way in which claimants could, if this scheme didn't exist, claimants could bring claims. We can't have it both ways. I mean, you say that the present statistics are really distorted by the fact that newspapers are being forced to settle, and then you try and rely on the fact that most cases succeed and are settled in a situation where you've removed this incentive by declaring the relevant subordinate legislation invalid.
No, it just means it's the wrong scheme for protecting Article 6 rights of claimants.
No, but we don't know what would happen, whether any of these claims could have been brought, putting it more bluntly, by people like Sergeant Flood or by the claimant in the present proceedings, without the benefit of the success fee scheme and the ATE scheme.
No, but we do know what the consequences are.
We do know what the
Publishers
are, and yes, that's true. But it may be that if none of them could have been brought, that would be a worse consequence in the opposite direction.
But that isn't the situation that we're dealing with. That's
know.
not the law that we're dealing with.
That wouldn't be the situation.
Well, I know, but this is a challenge to a law. It's a challenge to a general measure, and I can only address the consequences of the general measure as impugning the legislation under Article 10, because that's the system that we have.
But somebody's made a judgment, I mean, maybe they aren't necessarily right, that this system should survive for the press alone.
Well, I'm going to come on to that. I'm not sure that judgment has been made.
Right.
But could I come on to that, the history?
There are other exceptions as well, aren't there? Mesothelioma cases and so on.
One of the other two has gone.
It's insolvency, I think, has gone.
Insolvency has gone.
Some of them have gone.
Yes.
I think, is this the only one that remains?
I think mesothelioma still remains. Yes,
Right.
is the other one that remains. The second element of the regime in issue is the recoverability, in addition to the success fee, of the claimant's AT insurance premium. Prospect of being held liable for this, we say, only adds to the pressure on publishers to settle cases with worthwhile free speech defences and to avoid publishing such material. Again, we say this is an interference with freedom of expression which cannot be justified under ECHR Article 10.2, especially because the AT premiums are very high in this small area of litigation. There is no competitive AT insurance market to control the levels of premiums. The third element in issue is the lack of any effective judicial control over the sums publishers are ordered to pay. The provisions that determine how these sums are to be assessed in this case are in the relevant parts of the pre-1st of April 2013 CPR, and more importantly, in the cost practice direction under the old CPR Rule 44. This is at Bundle 4, tab 25. The relevant paragraphs being 11.5 to 11.10.
There we go.
Pages 1199 to 1201.
Thank you.
The court will be familiar with these. They include the principle that the amount of additional liability has to be considered separately from the base costs. That's 11.5 at 1199. And the principle at 11.9 on page 1200 that a success fee cannot be reduced simply because the total of base costs and success fees appears disproportionate. The way in which the regime works in practice was explained in the judgment of my Lord Neuberger and Lord Dyson in Coventry and Lawrence at paragraphs 40 and 41. That is at Bundle 8, tab 6, page 2824.
Yep.
In essence, if it was necessary to incur the ATE premium in that amount at that stage in the litigation, it was proportionate, irrespective of whether it was a proportionate amount of money given what was at stake in the case. And if the base costs were reasonable and necessary, a reasonable success fee would be regarded as necessary and so proportionate. If the claimant's lawyers identified a 50% chance of failure, they could reasonably charge a success fee of 100%. This is what's known as a ready reckoner approach to enable the lawyer to come out even and recover his or her normal costs across the caseload, assuming a caseload of winning and losing CFA cases. We say the problem in publication litigation is that there aren't many losing cases, and solicitors are therefore able to take on predominantly winning cases. Just for your Lordship's note, there's a more detailed summary of how the statutory regime for recoverability of additional liabilities operates in our written case at Bundle 2, Tab 5, Paragraph 10, starting at page 597. The court will recall from the various written cases there's a different CPR rule in relation to proportionality to the one that applies to the assessment of costs in this case. The rule changed as from the 1st of April 2013. And if you look at the current rule, which is at Bundle 4, tab 30, page 1325, you will see the new proportionality rule essentially in 2A, which says costs which are disproportionate in amount may be disallowed or reduced even if they were reasonably or necessarily incurred, is the key proviso that's been added in. And then at 5, this is 44.35, costs incurred are proportionate if they bear a reasonable relation to proportionality to, and then there is a new list of factors that can be considered. This doesn't apply in our case because of paragraph 7, which you'll see over the page at 1326, says in terms paragraphs 2A and 5 do not apply in relation to cases commenced before the 1st of April 2013.
Is that the point on which there seems to be a difference between the current senior costs judge and one of his colleagues?
No, I think the difference is whether the new proportionality rule, assuming it applies to that case, essentially as to whether it applies to additional liabilities as well.
Yes.
He's held it does.
Quite right, yep.
Master Gordon Straker has held it does, and others have disagreed.
Yes.
What's really said now.
And if it does, how do you approach it? Do you do it at the end or do you do it at the beginning, and so on and so forth? But I'm in the happy position of not having to tangle with that dispute in our case because we, under sub-rule 7, are simply not in this new regime. And I'll leave Mr. Lord Panic to deal with that issue. So I turn to the ATE and the uplifts in our case, in Miller. If I could just take you in 2 volume 2 to the judgment of Mr. Justice Mitting at page 701, tab 7, 27701. He describes helpfully and in short form at paragraph 1 of his judgment the position in relation, the initial position. The initial uplift was, and I'm summarising, you can get this in the bottom third of that paragraph. The initial position was 100% uplift for the solicitors, Mr. Miller's solicitors, 100% uplift for counsel after service of the defence, so it was stepped before that but rose to 100% very early on in the proceedings. And the ATE was also stepped at the outset with the premium rising to £65,000 plus insurance premium tax for £100,000 of cover 45 days before the trial. Then at paragraph 3, Mr. Justice Mitting, top of page 702, explains that in March 2012, new leading counsel was instructed for the trial. He assessed prospects of success at 55% and charged a success fee of 82% on that basis. And then finally, at paragraph 4, in May 2012, with the trial approaching, the ATE cover was increased to £360,000. And here you will get a feel for the high level of premiums with a premium of £234,000. Before turning to look at Campbell number 2, I want to make some brief points about the history of the regime in relation to publication cases. Publishers were first faced with this recovery regime when it was introduced in 1999 in an attempt to increase access to justice across the board. The court may recall that CFAs and ATE were already available, though without recovery against the opponent of the success fee and the premium, in nearly all civil claims. Only certain family and environmental proceedings were excluded. Because recoverability was introduced as a general measure for all of these civil claims, notwithstanding the adverse impact on freedom of expression, no justification specific to publication claims was advanced by the government at the time of its introduction. Claims against publishers were simply caught up in a more general move to funding litigation by CFAs with ATE. One of the aims was to replace legal aid, but this had only ever been available in a handful of special cases for defamation. As a general rule, it was not available. As the court knows, following the Jackson report and MGN versus UK, LASPO 2012 ensured that from the 1st of April 2013, the 1999 Act for Regime for Recovery ceased to apply to new CFAs and ATE insurance taken out after that date. But as I've said, the 2005 order, the 2012 order, LASPO order, maintained the position for publishing cases. As I've mentioned at the outset, it has remained in place to date, still without any specific governmental justification for it, as distinct from other possible access to justice measures in publishing claims. As the court will have seen from our written case at paragraph 64, which is at volume 2, tab 5, this was said by the government to be a short-term position. The LASPO commencement number 5 saving provision order 2013 was said to be a short-term saving provision while a costs protection regime for publication cases was being worked out and introduced.
Which paragraph is that?
It's
64.
64, Volume 2,
Yes, I
Tab
got it.
5, 625.
Yes.
Yep.
This has not happened, even though in March 2013, a working group of the Civil Justice Council charged with identifying an alternative cost protection regime identified a very carefully thought through form of qualified one-way cost shifting as the preferred means of cost protection in such cases.
Sorry, who did that?
There was a working group of the Civil Justice Council set up to consider such an alternative scheme, and it reported in March 2013, and its proposals have just laid on the table, essentially, since then.
I mean, you're going to come to it, presumably, but there is a scheme of cost shifting. It's simply that it has with it baggage that the media isn't prepared to accept.
This is a protection scheme because
No, but there is another one, isn't there?
for the post-Jackson cases.
Quite.
Absolutely.
Yeah.
But we're not in that. We're out of that. So we haven't had the benefit of that. We've been exempted from that in publishing cases. We still face the prospect, by we I mean news publishers, of paying very high ATE premiums as the price of the cost protection. So I turn to Campbell number 2. This is at Volume 6, Tab 8, 2074. Naomi Campbell had won her appeal to the House of Lords and been awarded her cost. Her solicitors and counsel had acted on CFAs with uplifts of 95% and 100% respectively. Her base costs recoverable were yet to be assessed in the House of Lords, but the claim was for £314,000, including disbursements for the appeal to the House of Lords.
The House of Lords only, wasn't it?
Yes.
She managed without up until then.
Exactly. We're only speaking about the substantive appeal and the consequent petition by MGN. The success fees claimed on the substantive appeal came to £280,000, and MGN petitioned the House of Lords challenging the recovery of the success fees, relying on Article 10. The main speech in the appellate committee was that of Lord Hoffman, as you know, with whom the other members of the Judicial Committee agreed. And if we could start with paragraph 19 at 209 to 2080, your lordships will see that as here, the respondent argued that there was no harm in a cost regime that inhibited publication of material found to be defamatory or an invasion of privacy. Lord Hoffman correctly rejected this point in the passage that I've referred to. He says at the bottom of 2079, it's true that costs awarded against defendants who have been found to have wrongfully published matter which is defamatory on breach of a claimant's right to the confidentiality of personal information. So it may be said, and Ms. Campbell's counsel does say so, there is no harm in inhibiting such publications, but that, it seems to me, is not the point. It is the effect of the threat of heavy liability, the effect which the threat of heavy liability may have upon the conduct of a newspaper in deciding whether to publish information which ought to be published, but which carries a risk of legal proceedings against it. When the European Court of Human Rights in Tolstoy-Miloslavsky said that damages of 1.5 million in that case were excessive and disproportionate restriction on freedom of expression, I'm sure that they did not mean that people should be free to publish gross, deliberate libels at an affordable price, like the ancient Roman in the story of Aulus Gellius, who was followed by a slave carrying a bag of coins to pay the depreciated statutory penalty to the people whom his master insulted. The court was concerned with the indirect effect of a high level of damages awards on the ordinary bona fide work of the media. And that submission, when it's made in this appeal, should be rejected by this court, although it may be a struggle to come up with an equally colourful way of rejecting the submission. Paragraph 22, at page 2080, MGN's argument under Article 10 was that in the circumstances of this case, an award of costs increased by a success fee is for two reasons disproportionate. It's at the bottom of 2080. And if you read on, you can see that these were as follows. One, that the total was disproportionate that would be awarded with the success fees because it was nearly twice the amount which a cost judge would consider reasonable and proportionate on a base cost assessment. And two, the fact that Naomi Campbell had sufficient resources to fund an appeal to the House of Lords without CFA. So the challenge in this case was limited to the particular and unusual circumstances of the case, the cost claim in an appeal to the House of Lords being doubled by the addition of success fees. If you turn to page 23, you will see over the page at 2081 that the first point was very shortly dispatched by Lord Hoffman. He said it was flawed because it equated the concept of proportionality in the CPR on an assessment of costs to the convention concept of proportionality of an interference with freedom of expression, which comes into play when the state seeks to justify a restriction on freedom of expression as necessary in a democratic society under Article 10.2. The convention issue that would arise is the one identified by Lord Hoffman between B and C, namely whether a rule which requires unsuccessful defendants not only to pay the reasonable and proportionate costs of their adversary in the litigation, but also to contribute to the funding of other litigation, is a proportionate measure to provide those other litigants with access to justice, having regard to its effect on the Article 10 right to freedom of expression. So that is the argument that MGN should have put, and in substance did put in the Supreme Court, being formulated for them by Lord Hoffman, but it was not the argument they in fact put. He goes on to say MGN do not really deny that in principle it is open to the legislature to fund access to justice in this way. Paragraph 24, Lord Hoffman also dispatched the second argument fairly straightforwardly. Again, this was a case-specific argument. He said that Parliament was entitled to have a CFA scheme without means testing for somebody like Naomi Campbell because of the impracticality of means testing the few people who desired the CFA who couldn't fund the litigation themselves. And you can see the conclusion on the second point at paragraph 27 on page 2082. There's no need for me to read that. In the remainder of the decision, those 2 points having been dispatched straightforwardly in that way, there are a number of general comments about the applicability of the success fee part of the 1999 Act regime in publishing cases. And I'll just mention some of these. At 31, Lord Hoffman discussed what he called the blackmailing effect of a CFA in such litigation. And you will note that he set out paragraph 58 in Lord Justice Brooke's judgment in the libel case King versus the Telegraph, in which reference was made to the claimant solicitors, I think Messrs. Carter-Ruck in that case, having incurred base costs of £32,000 by the time of the close of pleadings. So the claimant solicitors revealed that by the time the original statements of case had been exchanged, they had already incurred costs in excess of £32,000, some equivalent to a potential liability of £64,000 on the other side on the basis of 100% success fee. And you can see from that how the high potential cost exposure of the media organisation can kick in from the very earliest stages of the procedure. Paragraph 34 on page 2085, in the last 4 lines, he noted that neither cost capping at an early stage nor assessing costs later deals with the threat of having to pay the claimant's cost at a level which is by definition up to twice the amount which would be reasonable and proportionate. Various of the respondents in this case make points about softening of the assessment regime for base costs, but that is the answer, we say, and it's pithily identified by Lord Hoffman there. It's not that that's the problem, it's the problem of the doubling up through the success fee. At 37 on 2086, Lord Hoffman noted that publishers could not do what personal injury lawyers had done faced with this regime, viz. Contesting many assessments of costs in CFA cases, so as to force claimant lawyers to take a lower compromise figure and then pass on the total cost to their insured. He says, 37, the publishers do not have the same negotiating strength as the liability insurers because there are few assessments to be contested, and disputing them involves considerable additional costs. So he concluded at the end of that paragraph 37, finding ways of ensuring the impecunious claimant can also do this may be more of a challenge. In the end, therefore, it may be that a legislative solution will be needed to comply with Article 10. At page 2089, paragraph 48, Baroness Hale described this as, in her words, a separate question to that raised by the appeal. She said it's a separate question whether a legislative solution may be needed to comply with Article 10. And at 57, right at the end, page 2091, Lord Carswell said that he wished to add by way of a tailpiece that he saw considerable force in the comments made by Lord Hoffman in the concluding paragraphs of his opinion. So we say, and this is our submission in relation to Campbell number 2, that it was not a decision which resolved or resolves the wider issue before this court in these 3 appeals, namely whether the statutory scheme as a whole under the 1999 Act is incompatible with Article 10. It was simply a decision on the 2 case-specific arguments raised by MGN against the recoverability of the very high success fees claimed by Ms. Campbell's lawyers on her appeal. The Judicial Committee, however, saw the possibility that the scheme as a whole might be so incompatible. Which brings us to MGN versus the UK. This is at bundle 12, tab 3, page 4086. Sorry, 4806. MGN had brought an application under Article 10 in respect of both the substantive decision in Campbell and the decision that we've just looked at under Article 10 regarding the decision in Campbell number 2. 2 applications were dealt with together by the European Court of Human Rights. And what I want to do is just look at how the Strasbourg Court approached the second application regarding success fees. At page 4833, paragraph 89, through to paragraph 99, that is pages 4833 to 4836, in a long section in the middle of the judgment, the court set out in great detail the provisions of the primary legislation, the CPR and the CPD, and also the domestic case law bearing on CFAs and success fees. My learned friend Mr. Rampton took you to some passages in that part of the judgment earlier on. It then summarised the public consultation processes that had taken place since 1999 on CFAs and ATE, and the conclusions of the Jackson report in January 2010. This section runs from 100, paragraph 100, through to, on page 4836, all the way through to 115 on 4841. In particular, the court will see that at 113 on page 4839, it noted the 4 flaws in the success fee regime identified by the Jackson report, namely its availability to any litigant irrespective of means, the CFA client not exerting control over the costs being incurred in his or her name, thirdly, the excessive cost burden imposed on the losing party and the blackmail effect that exists during the litigation, and fourthly, the potential for claimant solicitors to pick mainly winners, generating healthy profits through success fees. At 114 on page 4841, the European Court noted Sir Rupert's comments about what he described as the bizarre and expensive system for cost protection through the system of recoverable ATE. And at 115, again on the same page, 4841, it noted Sir Rupert Jackson in his report expressing concern about the widespread use of CFAs with ATE in publication cases, which could impose a disproportionate cost burden on defendants. It then noted at pages 4842 through to 4845 the various public consultation processes that had taken place since Jackson in 2010. The general principles for determining whether an interference with freedom of expression, such as an award of costs in a publication case, can be regarded as necessary in a democratic society under Article 10.2 was summarised in the section of the judgment dealing with the first application. These are very familiar, were touched on by my learned friend this morning, and included, if you turn to paragraph 141, at page 4849, the duty of the press to impart information and ideas on matters of public interest and the right of the public to receive them. It is to be noted, we would say, looking at paragraph 142, that in resolving the first application, the court correctly identified the need to balance Article 8 against Article 10. This balancing had to be undertaken, and this is an important point, because the publication of the articles and photographs in issue in the domestic proceedings interfered directly with Ms. Campbell's Article 8 rights. So the litigation in our courts, in the domestic courts, involves what is known as the horizontal application of the Convention. A clash, if you like, of convention rights between two private persons. And so the court in Strasbourg, when it came to the first application, had to consider the House of Lords' reasoning and conclusion in finding on the facts in the Campbell case that Article 10 did not outweigh Article 8. And that application, of course, failed. MGN was unsuccessful in questioning the reasoning and conclusion in the substantive proceedings. But the point I'm making was an exercise of a very different nature to the one involved in the second application. The summary of MGN's arguments on the second application are at page 4853 through to page 4854. And again, I won't read them all to you, but they show that, the summary shows that before the Strasbourg court, MGN drew on Jackson and the consultations to advance a series of arguments as to why the CFA's success fee scheme, as a general measure, was incompatible with Article 10. And I too would ask you to note, as my learned friend did this morning, especially 168 on page 4854. The submission was made in terms that publication cases should, for this reason, be excluded from the scheme. The government did not try to justify the scheme in publication cases per se. In other words, it didn't take head-on in Strasbourg the implications for freedom of expression, especially by the media. And you can see this at paragraph 170 on page 4854. The court records the government considered the court should examine only the underlying legislative provisions, namely the overall scheme, which permitted a person to enter into a CFA in practically all types of litigation with a success fee which could be recovered against an unsuccessful defendant in order to fund litigation by other persons. No doubt, this is my comment, no doubt this was because, as I've already pointed out, the scheme had not been introduced as a scheme for publication cases. So the government could not say it had been introduced to pursue the legitimate aim of access to justice in publication cases per se. 175 on page 4855, the Strasbourg Court begins to go through the methodology of Article 10.2. So, having found an interference, it says the legitimate aim identified by the government was promoting access to justice as guaranteed by Article 6. On the question of whether the scheme for recovery of success fees could be justified in a democratic society, the government emphasised the significant margin of appreciation to be afforded to the state in enacting a scheme of general application in support of policy objectives. And you'll see that at 176 at the bottom of page 4855. It emphasised that contracting states were entitled to adopt rules and schemes of general application in support of social policy objectives, and in conceiving of such schemes were required to carry out a delicate balance of a range of relevant competing societal and public interests, including, as in the present case, issues under Article 6 and 10 of the Convention. And at 177 on 4856, the government also argued that there were sufficient safeguards in the recovery scheme to protect unsuccessful litigants.
There's a funny element of this, isn't there? Here we have all these exhaustive arguments raised in Strasbourg, which you are asking us to apply, effectively, or adopt, give effect to the Strasbourg court's conclusions on them, and anyway. But normally, to go to Strasbourg, you have to exhaust your domestic remedies, and these points don't appear to have been argued in Campbell and MGN, which is a case which went to Strasbourg, effectively, isn't it? I mean, you showed us, or we were shown, the two arguments that were raised in the House of Lords, and I mean, the first one was dismissed pretty briefly on the basis that proportionality meant different things in the rules and in the Human Rights Convention, and with the final comment, MGN don't really deny that in principle it's open to the legislature to choose to fund access to justice in this way. And then they go off to Strasbourg and argue the opposite, admittedly through different counsel.
Yes, but you only have to exhaust your remedies. So they had, in the only forum they could, or the best forum they could, namely the Appellate Committee of the House of Lords, sought to prevent the recovery of the success fees.
Yes, but you have to presumably...
That makes the application admissible in Strasbourg.
Well, I mean, don't you have to exhaust them by raising the relevant arguments? Anyway, that's the oddity. That
I don't think so. I don't think so. There are plenty of cases in Strasbourg under Article 10.
You can have second thought.
Not many from this jurisdiction, but from other jurisdictions where the full Article 10 argument hasn't been put.
Anyway, that is roughly what I put an accurate summary of the position.
Yes, but the disparity in the way the cases were argued in the two jurisdictions. The point I'm making is it doesn't deny you admissibility.
No, I see that. Well, I mean, it obviously didn't.
Didn't. They accepted the case was admissible. The government at 180 did respond to the MGN argument that publication cases should be excluded from the scheme. It wasn't the basis of its argument that the scheme was justified as a scheme for publication, but you'll see what it says. It says, as to the applicant's suggestion that publication cases can be excluded from the system, there was no reason to suggest that those involved in publication cases should have less access to legal services. Cases against newspapers concerned important and sensitive rights for which CFAs should be available. And since legal aid was never available for defamation cases, those on modest incomes could not consider bringing or defending such actions without CFAs.
That's the government's argument.
Yes, so it did counter the suggestion you should take publication out, but it was as part of an argument that the whole scheme justified the inclusion, if I can put it that way. The court concluded that there had been an interference with MGN's Article 10 rights in the sense identified in Article 10.1 by the requirement to pay success fees. It also concluded that the interference was prescribed by law, all the provisions that we know about, and that the introduction of the scheme had pursued the legitimate aim under Article 10.2 of the protection of the rights of others. Namely, as you'll see at 197 on page 4859, the widest public access to legal services for civil litigation funded by the private sector. That was the legitimate aim. And it also accepted the government's arguments, which we looked at a moment ago, that there had to be a broad margin of appreciation where the state was balancing competing interests such as access to justice under Article 6 and freedom of expression. And you'll see that at paragraph 199 at pages 4859, 4860, and that there had to be a broad margin of appreciation available to a legislature in implementing social and economic policies. The court will respect, this is 200, will respect the legislature's judgment as to what is in the public interest unless that judgment is manifestly without foundation. So it accepted the two key planks of the government's case for the scheme not violating Article 10 and being within the margin of appreciation. But and this is the important part, as my learned friend Mr. Rampton has pointed out, at 201 on page 4860, it also noted two fundamental principles in Article 10 case law. Mr. Rampton read this paragraph to you earlier. The latter principle, so the first one is that one has to carefully scrutinise measures capable of discouraging the participation of the press in matters of legitimate public concern. And that comes from, see the footnote at 63, the well-known cases of Jersild in Denmark and Bladet Tromsø versus Norway. The second proposition, not necessary to consider in any particular case whether a damages award has a chilling effect on the press as a matter of fact, is a very important one. And it translates to a very high costs award. It doesn't have to be just a very high damages award. Now, this latter principle may have been misunderstood by the respondents in their submission in these cases, where they say there is no evidence. We have been unable to cite any evidence that success fee or ATE recovery has a chilling effect in relation to public interest journalism. That is not the issue. The issue in Strasbourg is whether the measure, which is what the court focuses on, is capable of having such an effect. Under Article 10, it is an absolutely fundamental principle that you focus on the measure in issue rather than evidence about its effect. And that is because the chilling effect is very difficult, if not impossible, to prove forensically across an entire democracy, across an entire newspaper system. Can't be proved forensically. So this is an approach which precludes the state raising the argument against an applicant in Strasbourg that it has to be proved forensically in that way, but that the applicant has failed to do so.
So which paragraph is it that you get that out of?
It's the second principle at 201.
Yes, thank you.
And if you look at the footnoted cases, and indeed a long tail of cases in Strasbourg, you will see that principle being articulated. And that's why, in the first principle, the key word is capable of, what the court looks at. I obviously won't read 202 to 215. It's a lengthy passage at 4860 through to 4863. But the court noted all of the flaws in the CFA scheme that have been identified by the Ministry of Justice and Parliament in the public consultations and by Lord Justice Jackson that bore on the position of the media in defamation and privacy proceedings. And at 216, it rejected the government's contention, this is on 4863, which I referred to earlier, that there were in fact sufficient safeguards against disproportionate costs orders against media organisations in success fee cases. Noting at the end of that paragraph that the relevant provisions of the CPR and the CPD had all been in place throughout the entire period of the public consultations and the Jackson Review, and they had not prevented the conclusions in those exercises that orders for full success fees were routinely made in publication cases. So this reasoning leads to the broad and well-known conclusion 217, page 4864. The court considers the depth and nature of the flaws in the system highlighted in convincing detail by the public consultation process and accepted in important respects by the MOJ are such that the court can conclude that the impugned scheme exceeded even the broad margin of appreciation to be accorded to the state in respect of general measures pursuing social and economic interests. It is important to note that the citation at the end of that paragraph, at footnote 80, is Tolstoy-Miloslavsky versus the UK. at paragraph 50. And I just want, if I may, to go to that. It's in bundle 12.
Yep.
Tab 9, same bundle. 5080. As my own friend mentioned, this was a case where a jury award in this jurisdiction of £1.5 million in libel damages was found to be a violation of the defendant's Article 10 rights. I won't read the whole paragraph. Paragraph 50, but the thrust of the Strasbourg Court's conclusion, this is on 5080, is at the end. It noted that the Court of Appeal had recently, in Ranson versus Mirror Group, observed that to grant an almost limitless discretion to a jury failed to provide satisfactory measurement for deciding what was necessary in a democratic society for the purposes of Article 10. And by the time the case came before the Court of Appeal had acquired a wider power to overturn jury awards in defamation cases, to exercise some form of judicial control. The Court said at the end of paragraph 50 and into 51, the Court cannot but endorse the above observations by the Court of Appeal to the effect that the scope of judicial control at the trial by the trial judge and on appeal at the time of the applicant's case did not offer adequate and effective safeguards against a disproportionately large award. Accordingly, having regard to the size of the award in the applicant's case in conjunction with the lack of adequate and effective safeguards at the relevant time against a disproportionately large award, the Court finds that there had been a violation of the applicant's rights under Article 10 of the Convention. So what at 217 in MGN versus the UK, the Court of Human Rights is saying is exactly the same thing. It's making the point that the regime under which costs orders for success fees are made in favour of claimants with CFEs in publishing cases simply does not offer the necessary judicial safeguards against disproportionality. And then back in MGN versus the UK at page 4864, paragraph 218, the Court goes on, as it characteristically does in cases where it's identified a general measure as being incompatible with the right, to look at the facts of the particular case that's been brought before the Court and using those facts to support the conclusion in relation to the wider outcome that the general measure is incompatible with the rights of the applicant.
If the Court had decided and not come to the same conclusion in paragraph 218 and had decided that on the facts the figures were not disproportionate, what would it have done, having come to the conclusion it did in 217?
There would have been no violation in the individual case, because it would have said, for whatever reasons operated in the domestic courts in this particular case, the offence doesn't arise. But you could still have a finding that the measure violates Article.
The measure violates, but in this occasion it hasn't caused a violation in respect to this particular person. Yes.
But of course it's the other way, the outcome is the other way around.
I understand.
As we say in this case, the figures in our case demonstrate perfectly the proposition, the general proposition is correct, just as the figures in Campbell's case demonstrated that perfectly. I want to deal with two of the respondents' arguments at this point. First, the respondent suggests in his written case that this was just a decision about the facts of MGN's case. That is, I'll just give you the reference. It's paragraph 27 in his written case at 26, page 649. He says the true ambit of the decision is narrow and directed simply to those specific success fees. Well, we're not sure which parts of the decision Malone and friends were reading, perhaps just paragraph 218. Clearly the decision was much more than that. He points, however, to the just satisfaction decision, which is in volume 12, the same volume, tab 2, in support of this contention. And you'll see that at page 4802, paragraph 16, when the Mirror group newspapers asked for just satisfaction in relation to the success fees they had been required to pay in relation to the substantive appeal, the government suggested that the principal judgment did not exclude a lower success fee might be proportionate. So the damages claim, the just satisfaction claim, had to be for less than the full percentage uplifts under the CFAs that they ended up paying. The court declined to speculate, as you can see from paragraph 16, as to the level, if any, at which a success fee could be considered proportionate. Now that passage does not support the conclusion that the respondent in our case draws from it. It is simply recognizing that the scheme being incompatible was not appropriate for the Strasbourg court to take the place, as it were, of the UK government in devising or hypothesizing an Article 10 compliance scheme for access to justice in publication cases. For example, one that might allow some recovery of a success fee. The court won't do that. It's not the job of the Strasbourg court to say what might be compatible or to proceed on a conclusion of its own in relation to that. And you can't approach just satisfaction on that basis either. But on this first point that the respondent takes, we're bound to say that even if it was just a decision on its facts, it's difficult to see how this helps, given that the success fees in each case, that is our case and MGN, are around 90% of base costs, and in each case the liability arose because the publisher lost the case and the relevant free speech defense was not made out. The second argument of the respondent I want to address is an important one. The respondent says, this is volume 2, tab 6.
Just before you go there, can you tell us how the court awarded €97,600 then? Is it possible to relate that to any of the figures in paragraph 7 onwards?
No. Mysteries of just satisfaction, I'm afraid, sometimes have to remain the mysteries of just satisfaction in Strasbourg. I know that the Mirror had compromised the claims. There hadn't actually been, well, maybe, could I leave alone for Mr. Panic to deal with this?
So there's somebody. It's a very precise figure, 97,600. Anyway.
It may have been that they worked out how many pounds and then translated it into euros. It may have produced a round figure in sterling.
I'll agree with that. That sounds about right.
But it doesn't help what that round figure was and how they arrived at it. Well, if anybody can cast light on it, we'd be very grateful.
Oh, I see. Right.
Leave that for the
Lord Panic will cast.
Leave that for the moment, Mr. Miller.
But the second argument is important. The respondent says at paragraph 78 in his case, to volume 2, 6. Tab 6, page 667, that in deciding whether recovery of additional liabilities in publishing cases is compatible with Article 10, this court has to take into account the fact that in such cases, the scheme is assisting access to justice for claimants asserting Article 8 rights. Now, this will be true, no doubt about that, for most, though not actually all, libel cases, and is certainly true in privacy cases. There is in the bundle a case called Yeo versus the Times, and also an interesting article by Aplin and Bosland at Melbourne University that assess when a defamation claim cannot be covered by Article 8. It's a tricky question that this court grappled with in the Guardian case as well. But there are some cases where Article 8 doesn't apply. But let's assume for the moment that that's true across the board. Mr. Rampton, in his submission, seemed to accept the proposition that what one was looking at here was, on one side, Article 8 and Article 6, and on the other side, Article 10. With respect to this point, we have to disagree with him and depart from his arguments respectfully. And I come back to the point I was making earlier. The second application in MGN versus UK was not a case about the horizontal application of the Convention on the facts, as the substantive claim was. It was a challenge to a law, to a domestic law. So it was a case involving the vertical operation of the Convention. The interference, in other words, that a state measure produces with a particular Convention right. Here, the justification under Article 10.2 has to be made out by the state, and we've seen how the UK government tried to do that in Strasbourg by reference to the Article 6 rights of all the beneficiaries of the 1999 Act scheme. The Strasbourg court, of course, was well aware that in many of the cases, as I've said, brought on CFAs against publishers, the claimant will be asserting the Article 8 right via the domestic cause of action. This is, after all, what Naomi Campbell was doing in the substantive claim. And as we pointed out in the government's submission referred to at paragraph 180, page 4856, the government stressed in support of that general argument that there were important rights at stake on the claimant's side in publishing cases. None of this, however, altered the conclusion reached by the European Court that the success fee recovery regime was incompatible with Article 10. Moreover, as we've pointed out, the government tried to justify the operation of the scheme in cases where Article 10 was engaged, not by suggesting that Article 8 claims were somehow more important in terms of access to justice than all of the other claims covered by the original system, so that the harm done to freedom of speech was justifiable, but rather on the basis that the scheme was justifiable for all cases. Indeed, it has never since tried to articulate the case that it's justifiable in publication cases, simply because many of them will assert Article 8 rights. So it is a misconception. This is a horizontal application case, and all kinds of important rights were at stake in the other claims that benefited from the scheme that were argued about in Strasbourg. And it doesn't undermine the judgment at all to point out that on the facts of some publication cases, Article 8 is a right being engaged on the claimant's side.
Can I just explore that with you just a moment? In the MGN case, the court rejected the justifications advanced for the scheme as a whole. Is the result necessarily the same when, in a horizontal case, one is dealing with a case where there are serious difficulties, where the successful litigant has embarked on the litigation on the basis of a particular state of law? Now, it may well be that while the scheme itself as a general proposition can't be justified, nevertheless, its application can be justified in a particular case where the alternative would be to leave people who have embarked on litigation on the basis of a particular set of rules about costs in a position where they are effectively busted because of the debts that they, in consequence, owe to their own solicitors.
But that would have applied in all the cases across.
No, it would only apply in cases. I mean, there is a difference, isn't there, between saying this is a scheme which a compliant state should not have, and saying, well, they've got it, and for the future we can deal with this, but in relation to existing litigants, there are considerations of basic justice on the other side, which mean that it may have to be accepted for the present. That's
Well, I mean, the Convention, following a judgment in relation to a general measure, the Convention leaves it to the contracting state to decide, in effect, if you like, what to do to avoid future violations
Yes.
under the Convention right for the reasons identified in that decision. And either the government legislates, or if there are means available to the courts, they find a way of developing the law so as to avoid violations in future cases. That I think, is as far as the Convention goes. It kind of throws the problem back to the contracting state to bring its law into line with that identified in the Convention. And the problem in this case, of course, is that that hasn't happened. So we haven't had a government legislating to solve the problem in a way that's Article 10 compliant. And the courts have been left, which is the other possibility, to find ways of remedying the Article 10 violations that flow from the relevant law. But I mean, I'm afraid our short answer to that is it's not our concern in this case. I mean, on the facts of this case, success fees and a fortiori ATE are plainly applying the reasoning. A good example of the general measure producing an incompatible outcome for exactly the same reasons identified in Campbell. And we are not the state. We are entitled to rely on the court to give us a remedy.
Well, on that point, can I ask you just to have a look at Section 8 of the Human Rights Act, page 1067 in Volume 4? Because you observed at the outset of your submissions this afternoon that the application, given the terms of Section 6, 1 and 2 of the Convention, was mandatory. Section 8, on the face of it, appears to envisage that in a case where the act of the relevant public authority, in this case presumably the judge, the Court of Appeal, and the makers of the costs order, were unlawful, a court may nonetheless grant such relief or remedy or make such order within its powers as it considers just and appropriate. Is it fair or not to deduce from that that there may be circumstances in which one has to consider the impact as a matter of general justice of any particular order on other litigants before deciding exactly what relief to grant?
No.
Why not?
Because this is, as I understand it, this is the domestic equivalent of the just satisfaction provision. But if a violation is identified by the court in this jurisdiction, it can provide a remedy.
Well, it certainly includes that, but is it limited to that?
Well, it begs the question whether if the scheme is in violation and the outcome would be in violation, and the court would be acting unlawfully to make the order complained of.
But if we were to think it
would be acting within its jurisdiction to do anything else.
But if we were to think it was unjust on the respondent, in this case, for example, to deprive him of costs which he legitimately expected, could it really be said that we consider it just and appropriate to make the order that you would like us to make?
I mean, we're with Mr. Ramps on this. We don't want you to make any order. We just want you to declare that our liability for the additional liabilities incurred in this case, an order requiring us to pay those would be unlawful.
That's horizontal. That's a direction, an order of horizontal effect, isn't it? It removes a judgment which otherwise the successful claimant would have had.
Setting aside the judgment. And that course would amount, wouldn't it, to setting aside the judge's order so far as it was on your submission incompatible.
The order hasn't been made yet. There is no order yet.
What the judge has?
The judge.
I see.
Below ruled that an order in
yes.
full amount.
Well, all right.
Would be compatible.
Yes.
But we halted the assessment proceedings, so there hasn't actually been an order yet.
All right, but it doesn't. Come on, nevertheless, it's a horizontal. It's a direction of horizontal effect, isn't it? Which deprives the opposite party to the private law case of something which otherwise he would have.
Yes, but if their convention rights are violated in consequence, or they have some other form of claim against the government, they can pursue a claim against the government. But the government has allowed a state of affairs to continue in which the media's Article 10 rights are being violated.
That may well support a claim against the government of the kind envisaged in Section 7, and a claim for damages of the kind envisaged in the subsequent subsections of Section 8. But I don't think it directly answers the problem that I have, which is what is a court to do in the admittedly very unusual circumstances, but we seem to be facing them here, where there would be really very serious injustice to another party in effectively directing that the statutory regime under which he had committed himself to bringing the claim was not to be applied.
Well, I was going to come on and address the facts in relation to remedy.
I quite see that you may well submit that it wouldn't be so unjust on the facts of this case and so on.
Wouldn't be unjust.
Or indeed that which is Mr. Lampton's submission, that the importance of Article 10 is so great as to override any instincts that one might feel to exercise the Section 8 powers in that way. But in principle, you're submitting, as I understand it, that we simply can't refrain from giving you a remedy, whatever the injustice to the respondents. That is your submission, is it not?
That's the effect of Section 6, yes.
Yes, I see.
Yes.
Well, on Section 6, I'm sorry to take you out of your way for so long, but looking at Section 6, can you help me on what is meant in Section 6, sub 6b, by a remedial order? I mean, 6 sub 6b is a very odd provision because it says that an act does not include a failure to make primary legislation. The only outfit that could fail to make primary legislation being Parliament, which is not capable, which is not a relevant decision maker at all. See subsection 3. So it's a slightly odd provision anyway. But what is meant there by a remedial order? Does it mean a statutory instrument? Or does it include an order by a court?
No,
Section 10 helps, does it? Right, I'm grateful for that.
It's defined in Section 21(1) as meaning Section 10.
Right.
Declaration.
Yes, I see.
No, it's
right.
Post declarations of incompatibility.
Right. Okay, that answers that. I'm very grateful to you.
So contrary to European Union law, you can't sue the government for failing to pass primary legislation. Because...
Or its equivalent.
Or its equivalent.
Yeah.
Because
what was postulated, I thought earlier on by my Lord Sumption, was this may end up in being a violation of the Article 6 rights of the claim.
Well, that's a different point, but it is another possibility that if somebody, by virtue of having exercised his access to a court under the existing regime, then finds himself financially smashed up by the retrospective removal of that scheme, that might be thought to be difficult to reconcile with the concept of access. It's a point I suggested.
It might be, but that would be a question of fact, wouldn't it, on the particular?
Indeed, yes, but conceptually, that's one possible way of analysing it, isn't it?
It is possible, but I mean, it's not for us to argue that. I mean, if the respondents want to argue that that would be the consequence, they can argue that.
Well, I'm putting it to you in case you want to comment on it.
Well, it doesn't seem to us to come close to an Article 6 for reasons I'm going to come on to do with the chronology.
On the facts.
On the facts.
Right. Okay,
I understand
that.
This is a very different situation from Coventry and Lawrence. There were thousands of pipeline cases in issue in Coventry and Lawrence.
I think in paragraphs 89 to 92.
Yes, exactly. This is a very different ballpark, if I can use that expression. I mean, how many pipeline cases against the media, subject to new cases under the continuation of the regime, I don't know how many of them there are, but in our situation, in the old cases, there will be hardly any of those that wouldn't have been commenced in the period after Campbell No. 2, when the case was being taken to Strasbourg, when the media were, when MGN were contending on behalf of the media in Strasbourg by way of an application under Article 10 that Campbell was wrong, that success fees shouldn't be recoverable, and then, or after January 2011.
So you're saying there'll be hardly any cases in future where the legitimate expectation will arise?
Yes, and you're postulating these are people with sophisticated claimant lawyers acting on their behalf who are saying enter into a CFA. We assume they're saying don't worry about MGN's case in Strasbourg, or after January 2011, don't worry about the outcome in MGN versus UK. It doesn't mean, it won't have the result that you don't get your CFA or AT uplift. We don't know if that was the advice given in this case because they haven't condescended to evidence to tell us what the advice was. But as you will have seen, letters were written following the MGN versus UK case by my instructing solicitors saying, look, we think it applies, and what's more, we think it applies to ATE. And still the claimant went on the basis of the advice of his lawyers.
At that stage, had the ATE been taken out?
Oh, yes, absolutely. Well, no, at that stage, it was about to be increased substantially for the trial.
I see. So there was ATE, but...
It wasn't the quarter of a million. It wasn't the £250,000 ATE.
If you're right, Mr. Miller, is there any complication for cases which have proceeded to judgment and or settlement? Well, no, not settlement, judgment. What, if anything, happens to a late application for leave to appeal?
There will be. I would just preface my comments by saying there will be very, very few of those.
Why?
One would have thought, because very few publication cases with CFA and AT uplift.
But in principle, what would happen if there were?
If there were any others, it's open to any media organisation in the position of my client or the respondents in this case to take this point following MGN.
On a late application for leave to appeal?
No, I would have thought the opposite. The opposite.
Well, why not? You may well be right, but what's the mechanism for preventing it if an order has been made for additional liabilities to be met by a media defendant in a manner which we now hold was an infringement of convention rights?
But if you're outside the appeal time in circumstances where the law was all there in Strasbourg, and the point was available for you to argue, and let's face it, we've been arguing it for a while now. We appeared on behalf of the MLA in Coventry and Lawrence. We argued it before Mr. Justice Mitting. We argued it before Mr. Justice Mann last year. Anyone wanting to try and do it now will be well out of time.
Yes, they would. Yes, of course they would. But
that's slightly skating around the question. You're being asked to assume that a judgment was given for costs which we now know ought not to have been given.
Well, I'm being asked...
And it was given before we acquired that knowledge. Now, is it open to somebody to come along, a media organisation to come along and say, well, we'd like to reopen these cases that were closed before MGN was decided. We'd like to have late leave to appeal, because this is something that there was in effect no power to do. It was an illegal order.
Yeah, but you're asking me what a Court of Appeal judge would do in that situation.
No, I'm asking you what he should do.
The judge should do in your submission.
All I can say is I think it's very unlikely in the circumstances that we are now, that somebody who had delayed so long in the circumstances prevailing through the last few years in relation to this point, without having taken the point, it's very unlikely they'd get permission to appeal.
Well, that's probably right, but should they get permission to appeal?
That may depend. I mean, that's a fact-specific. You're asking me to speculate about the facts of the case. I mean, if it was egregious enough, I suppose they would say it's so awful that I should be given some sort of exception.
It isn't entirely hypothetical, Mr. Weber, because those of us who've had to grapple with an admittedly different jurisdiction in crime have this constantly.
Yes. Yes. Well, that's why I said there aren't any floodgates here, because I don't think there would be many of those cases. But all I can say is this point has been there to be. It has been there to be taken for a while in concluded cases. In settled cases, obviously, it's a different thing. But in concluded cases where there's a big amount of money at stake, it's not as if the point couldn't have been taken on the basis of MGN versus UK. So I'd imagine, I'm not a Court of Appeal judge, but I would imagine a Court of Appeal judge would say you may not get the exercise of the discretion. I don't know.
Well, that may be as close to an answer as we're going to get.
Well, you're the appeal judges. I mean, you can form your own view about what you would do in those circumstances. But I mean, our point is that...
That's true of any case. If we did that, we wouldn't need to hear any argument.
I mean, our point is an obvious one, which is that these arguments have all been out there for some time now on the back of MGN.
You say this. You say even to this extent that in cases where it's water under the bridge, there's a much weaker argument. You say a very weak argument. Yeah. In many cases, on the facts, it may be all right, but on the facts of this case, it wouldn't be unfair.
No, it wouldn't be unfair.
On the respondent, because I don't know. I'm just conscious you've got about sort of 20 minutes, 10 minutes this afternoon, 10 minutes tomorrow. We've put a lot of questions to you recently. I don't know if you're running up against time difficulties.
Let me jump ahead and deal with that now.
Of course.
The remedies issue. We gratefully adopt the argument of MGN at 116 to 119 in their case at 359, page 976, to the effect there's actually nothing in the relevant provisions of the CPD that prevents the cost judge disallowing recovery of ATE and success fees in their entirety. If this is wrong, CPD provisions, especially 11.7, 11.9, can and would have to be read down and disapplied so as to achieve this. We've got our case on that. The legitimate expectation of recovery as a possible reason why a party in our position shouldn't have a remedy was raised by the majority in Coventry and Lawrence. The respondent has relied on this in its written case to say there's a similar argument here, but the facts are different. Media organisation, what the respondent says is, look, media organisations were not bringing the sort of challenge we are now bringing in earlier years. The circumstances, however, need to be carefully, not simplistically analysed. From the point of the what we say the obiter dicta in Campbell number 2 onwards, there was the possibility of a legislative solution to the problem. In 2007, the MOJ consulted on possible changes to the cost regime in publication cases. 2009, there was another consultation. 2009, later on, the Jackson Review was announced. From the decision in MGN versus UK in January 2011 onwards, it was assumed by the media that there would be a legislative solution, so as to change the law in England and Wales in a way that would avoid the incompatibility identified in Strasbourg. The prospect of launching an in-principle cost challenge in a particular publication case where base costs were recoverable by the claimant, that's a concluded case, to the recoverability of the additional liabilities was not attractive, would be costly, would have to come up to this level because, as in these cases, the media organisation would have faced the argument that Campbell number 2 is binding, which is what cost judges have decided in the past and what Mitting J and Manjay decided in this case. It could hardly be justified as worthwhile, except in contested cases such as the present cases, where large amounts of money are at stake. There are not many of those. In other cases, the amounts at stake simply wouldn't justify it. especially given that it was assumed that the cavalry was about to arrive in the form of Parliament providing a legislative solution. So the absences of any cases like this in those years cannot be taken as acceptance by the media that additional liabilities were compatible with Article 10, so as to found a legitimate expectation that such a challenge would never be brought in a case such as Miller versus A&L or Flood versus TNL, even if a claimant incurred huge additional liabilities, the two slices, in the course of the litigation. Whether this respondent had a legitimate expectation that we would not challenge a claim for huge amounts of money by way of additional liability against this backdrop is a question of fact. He took out his initial CFAs and incurred his initial AT liability in September 2009. The application had already been communicated in Strasbourg to the UK government on the 24th of October 2008, and a decision was pending. There was an obvious possibility that MGN would win, with adverse consequences for his ability to claim the additional liabilities at the end of the case, given the operation of HRA Section 6. This risk increased dramatically in January 2011 with the judgment in Strasbourg, but he continued to incur those additional liabilities. There is no evidence as to what he, Mr. Miller, actually understood the risks of non-recovery were during those years. Still less after the letter at volume 2, tab 7, page 824, referring specifically to the decision in MGN versus UK from my instructing solicitor.
Are you reading from your case at the moment, or is this a separate note?
So from a note.
It would be quite useful to have it in writing.
We can do that.
Or just on this point?
Yes, we can provide a written note on the facts on this point. 824, on 26th of April, on the left-hand page, 823, RPC discussing this move to a much bigger ATE premium with the trial looming. So the premium will be a very significant sum, leaving aside for now whether that sum would ever be recoverable from our client, etc. Correspondence continued on the 9th of May 2011. RPC said at 824, we do not accept as a matter of principle that AT insurance premiums of the level you are considering would be recoverable from our client on a cost assessment, if they are recoverable at all. Whilst the decision in MGN versus UK related to success fees seems clear that the principle established applies equally to AT insurance premiums in cases which engage Article 10. And in the next, this third penultimate paragraph, they say, we're not going to consent to your client taking out further AT. Whether he does so or not is a matter for him. He will need to decide if this is something he is prepared to pay for and how much he is prepared to pay for it. If he is not, you will need to advise, this is to his solicitors, you will need to advise him on the likelihood of such premiums being recoverable. So it could hardly have been clearer. He was saying success fees is done and dusted in MGN UK. We consider it applies to premiums as well. You have to advise your client about the risks that we will challenge this after the case. He may have had a diminishing hope that he could recover the additional liabilities being incurred, but we say the facts make it utterly impossible for him to claim a legitimate expectation. We never said we would not challenge if MGN succeeded in Strasbourg. Still less after it succeeded in Strasbourg did we say anything other than the effect we will challenge.
But forgive me, Mr. Miller, you're tackling the question of his reasonable confidence that the system wouldn't change on the basis that his I'd rather not call it a legitimate expectation, but his hope, or no, his expectation, if you like, would be that you wouldn't challenge it. The question which I think we're all being asked to consider is whether his expectation might have been that whether you challenge it or not, unless the CPR and the CPD were changed, you'd fail. And that, moreover, any change would be prospective rather than retrospective.
That, we would say, that would be an incorrect understanding of the position under
Because of
the
MGN in the UK?
Yes.
Yeah, okay.
And that he should have been advised accordingly by his law.
And because of the court's powers under the Human Rights Act.
Yeah.
Yes, absolutely. So we say that there's always a point in this court when you realise you're relying on the extra minutes on the clock. I think I'm fairly near to the end for today. But we say...
10 minutes tomorrow, I think,
I've got 10 minutes tomorrow.
according to my timetable, which I've been given.
Yeah, I've got 4. I think I've got 2 or 3 minutes. Can I just make 2 short points about Coventry and Lawrence? I don't want to go to it. It was about the additional liabilities recovery scheme at issue in this appeal, that is the pre-1st of April scheme, but it was not a publishing case. Right. But the 2 points are, nothing in the judgments in Coventry and Lawrence suggests that MGN versus UK was understood by this case simply as a decision on the facts of that case, rather than a decision about whether the scheme fairly balanced Article 6 and Article 10 rights. And nothing in Coventry and Lawrence suggests that this court considered it should follow Campbell number 2, rather than MGN versus the UK, when considering Article 10 challenges to the scheme. So, Mr. Justice Mitting considered he was bound by Campbell number 2 in relation to success fees. On our analysis, he was not, because it didn't tackle the wider issues raised by this challenge. It was simply a rejection of the 2 narrow arguments advanced by MGN on the facts of that case. But even if this is wrong, we say that this court must now follow MGN, even if Campbell number 2 is, which we say it isn't, in conflict with it. And I'll deal with that point in the morning, if I may. That's a convenient point.
Good. Thank you very much indeed, Mr. Miller. We'll resume again then tomorrow morning at 10 o'clock. And meanwhile, the court is now adjourned. Very much indeed. See you all tomorrow.